And you said that before the accident, there wasn't even a scratch on your back bumper.
Yes, that's right. My car was like new.
Your Honor, I'd like to show the witness a picture.
Having to appear in a courtroom to present or defend a civil claim on your own behalf can be a frightening experience. After all, you're not a lawyer, and a courtroom can be very intimidating. How do you address the judge? What's the best way to tell your side of the story? And what kind of evidence should you bring to court are all common questions. This video was created to make you feel more at ease when you appear in court, and will explain what is expected of you when presenting or defending a civil claim. The scenes you are about to see have been selected for purposes of illustration only, and are just a few examples of the variety of claims brought into court. The scenarios in this program include claims involving a tenancy dispute, a motor vehicle accident, a termination of employment without cause, and a breach of contract. They were filmed in a civil courtroom, and the presiding judge is a member of the court. Again, for the sake of demonstration, our defendant through each scenario is Mr. Glenn, and the plaintiff is Ms. Levitt.
They never paid me that money.
In some scenarios, you'll be shown the wrong way, and of course, the right way to present your case. To have a successful day in court, it is important that you are prepared and organized, and that you properly present your case and the related evidence. This program will help you gain an understanding of the type of evidence you may be required to present to the court. You'll be shown examples of how to organize your evidence, common problems in presenting oral and documentary evidence, the nature of evidence which is allowed and evidence that is not allowed, the witnesses you may want to have at trial, and how to qualify and examine an expert witness. It is the responsibility of the parties, the plaintiff and the defendant, to call and present all of the evidence necessary so the judge can determine the rights and obligations of the two parties. The plaintiff is the person who brings the claim, and the defendant is the person who disputes or disagrees with the claim. The function of the judge is to listen to evidence presented by the parties and to determine what the facts are based on that evidence. The judge then applies the law to those facts to determine if the claim should succeed or fail. The parties must remember that the judge is neutral and will not become involved in helping either the plaintiff or the defendant in presenting their case. The judge may intervene if the evidence is not admissible or relevant to the issues raised by the civil claim, dispute note, and the counterclaim. The proceedings are started when the plaintiff files a civil claim. The defendant then files a dispute note, and then the clerk of the court sets a trial date or schedules a pretrial conference or mediation. The civil claim and the dispute note must clearly and concisely set out the matters giving rise to the claim or the defense of the claim. The purpose of the civil claim is to give the defendant information on the basis of the claim and notice regarding the amount of money being claimed by the plaintiff or the property that either party seeks to recover. The dispute note sets out the nature of the defense and provides particulars about any counterclaim the defendant has against the plaintiff. The file containing the civil claim and dispute note is given to the judge to preview prior to trial. These documents must also be exchanged between the parties before trial, so they know why they are coming to court and the nature of the claim or defense they will need to answer to during the trial. It is very important that you complete your documents properly and outline your case or defense on the claim or dispute note in detail. The court may not consider matters or grant judgment for claims that do not appear on the civil claim or dispute note. If you wish to amend or change the civil claim or dispute note, it can be done by way of a chambers application, or in rare circumstances, by application at the beginning of the trial. After watching this video presentation, you may still be unsure or uncomfortable with the presentation of your case. If you wish to become more familiar with what to expect, you may come to the courthouse and observe proceedings before the court at any time. In addition, you may wish to consult a lawyer. Now, let's go to the scenarios. The most common method of introducing evidence to the court is by way of oral evidence, that is, by speaking to the court under oath. Oral evidence can be introduced by you, by your witnesses, or by the other party and their witnesses. Remember that the aim of your evidence is to enable the judge to find the facts. Your evidence must be truthful and should be presented in a reasonable, concise, and organized manner.
Southwest, the night before and then again that morning.
You should remain calm, and all of the participants should be polite. Shouting, swearing, arguing, or rudeness will not be tolerated and will harm your chances of success. Also, remember to stand whenever you address the court, and the judge is always addressed as Your Honor. It is best to prepare at least an outline of your oral testimony and questions before the trial. Your explanations to the court and your questions should be as short and simple as possible, while still getting your point across. Remember that your oral evidence must be relevant to the claim, and its purpose is to prove that you have a basis for your claim and how much your claim is worth. One of the biggest problems with oral evidence is the hearsay rule. Hearsay evidence is second-hand evidence about what another person has seen or heard, and it will not be allowed. You or your witnesses must have personal experience of the facts you are testifying about. The court will not listen to your account of what someone else saw or heard, unless you were present at the time.
When I moved out of the apartment, it was in perfect condition and super clean. I even pulled the fridge and stove out from the wall and cleaned behind them, and
In this scenario, we'll first look at how not to introduce oral evidence. The plaintiff is suing her landlord for the return of a damage deposit he is withholding. She claims that she gave proper notice and that the apartment was clean and in excellent condition when she moved out.
So my friend who helped me move and clean the apartment stayed to wait for him. She told me later he showed up at 9 p.m. and they did the walkthrough. She said that he said everything looked fine, and then they exchanged keys, and he said that the move-out report and my damage deposit would be mailed to me within 10 days.
Is your friend here as a witness today?
No, she has to work today, but she told me exactly what happened and what he said.
I'm afraid that's not good enough. I cannot accept your testimony in this regard unless you were present at the time. Your friend should have been here to give evidence so that the defendant would have the opportunity to cross-examine her on her version of the events.
Now, let's watch a more successful introduction of oral evidence in the same trial.
So the defendant was supposed to come for the key exchange at 8 p.m., but he was late. I had to leave at 8:30 because I had an appointment with my new landlord. So my friend, who helped me move and clean the apartment, stayed to wait for him. She told me that he showed up at 9 p.m. and they did the walkthrough and the key exchange. I will call her to the stand next.
You'll have to go out and bring her in, please.
Thank you.
Witnesses are not allowed in the courtroom until called upon to provide evidence. Once your witness is on the stand, it is important to ask open-ended questions so that the witness provides evidence in their own words.
Could you tell the court from your own memory what the condition of the apartment was by 8 p.m.?
It was super clean and it looked really nice. I think it looked even better than when my boyfriend and I helped you move in, probably because we helped you paint the whole place last July. We had scrubbed all the walls and we'd cleaned inside the window frames and even the light fixtures, and we cleaned behind the stove and behind the fridge.
As you could see, this was more successful because the plaintiff brought the witness to provide direct evidence of what she did, saw, and heard. The plaintiff was not able to give this evidence herself in the first instance because it was hearsay evidence. Also, fairness requires that the defendant have an opportunity to cross-examine the witness about her version of events. You will be able to see an example of a cross-examination later in this video, in the demonstrative evidence scenario. In order to appear organized, it is okay to discuss the case with your witness before the trial, but you cannot attempt to change the witness's evidence or tell them what to say. The witness is giving evidence under oath, and their testimony must be the truth. Failing to tell the truth under oath can result in a criminal conviction and is taken very seriously by the courts. Again, testimony and questions should be direct and simple. You and your witnesses can only testify to their direct experience. You should not lead your witness with statements that you want them to verify or questions which suggest the answer you are looking for. In order to be considered by the court, testimony must be relevant to the claim. Now, let's look at our next scenario and talk about what we call demonstrative evidence. We've all heard that a picture is worth 1,000 words. In some cases, diagrams, pictures showing the condition of leased premises or the accident scene, or actual items such as damaged goods or faulty equipment will greatly assist the judge in understanding your case. For example, if you were suing your dry cleaner for ruining your suit, you should bring the ruined suit to court. This is called demonstrative evidence. Demonstrative evidence can be shown to the court when you refer to it in oral evidence, or when you are asking a witness questions about it. If something is too big or impossible to bring to court, you can take pictures of it, and those pictures are also demonstrative evidence. In this scenario, there is a dispute over damage to a car in an accident. The plaintiff is claiming $7,000 for repairs. The defendant says there was little or no damage to the car as a result of the accident. The plaintiff has told the judge her side of the case, and now the defendant has the chance to question the plaintiff about their case. This is called cross-examination.
Thank you. Mr. Glenn, do you wish to cross-examine this witness?
Yeah, I sure do, Your Honor. Okay, you said in your evidence that your back bumper was completely crushed and your rear window was broken in the accident, right?
Yes, that is right.
And you said that before the accident, there wasn't even a scratch on your bumper.
Yes, that's right. My car was like new.
Your Honor, I'd like to show the witness a photograph.
Hold on, Mr. Glenn. Where did the picture come from?
Your Honor,
If you are going to use pictures in court, make sure that you are the one who took the pictures, or you were there when the pictures were taken, or you have the person who took them with you in court. You will have to tell the court when the picture was taken, why it was taken, and what the picture shows. Let's see how a picture can help your case.
All right, you may approach the witness.
okay, I'm showing you a picture of the rear end of a blue car. Now, can you see the license plate number in the car in that picture?
Yes, I can. That is my car.
And you can see a small dent and scratch on the left side of the bumper, and there's no other damage at all, correct?
Demonstrative evidence can be very helpful to a judge who is faced with the task of determining what happened in a particular case and what damages, if any, to award. Dependent on the actual piece of evidence, you may bring the item into court, or you may bring a photograph. If you are bringing an item into court, remember the following. Tell the court what the item is and how it relates to your case. If you have photographs, have the picture taker in court to say where the picture was taken, when the picture was taken, what the picture shows, why the picture was taken, and that the picture actually represents what the picture taker saw. Now, let's move on to our next scenario and look at documentary evidence. In addition to the oral evidence you or your witnesses give in court, documents are another form of evidence that may help you win or defend your case.
Right here.
It is important to bring all documents that relate to your case to the court. If you don't bring them, your trial may be delayed, or you could even lose the trial. Examples of the types of documents which are required include correspondence with the opposing party, canceled checks or credit card statements, invoices and receipts, evaluations or appraisals, written contracts or agreements, estimates in relation to damages, pay stubs, or anything else which might help to prove your case to a judge. You should bring 4 copies of each document to the courtroom, including the original if you have it. You have to give a document to the court when you refer to it in oral evidence, or when you are asking a witness questions about it. In this scenario, the plaintiff is suing for damages for wrongful dismissal.
When I started this job, I signed a contract that said how much I was going to get paid and other things like what my responsibilities were and something about when I could be fired by my employer. I didn't do any of the things the contract said would get me fired, and I was always a good employee. I even had a really good job review just 3 weeks before I was fired. I have copies of it right here.
Madam Clerk, thank you. Would you mark that as Exhibit 1 in these proceedings?
Now, if you look in paragraph 7 of the contract, it says that because I was not fired for being a bad employee or not doing my job properly, I should get 3 more months of my salary. I can show you I was a great employee. This evaluation was done just before I was fired.
As you can see, having the right documents is important to you and your case. So let's review the important points about bringing documents to court. 1. Review your records before coming to court. 2. Bring original documents, and only bring the documents that relate to your case. If you are unsure of any given document, bring it along, and the judge will decide if it is relevant. 3. Bring 4 copies of each of your documents. 4. Give the documents to the court when you refer to them in your oral evidence or in questions to a witness. Make sure your documents are well organized. The documents that you need depend on the type of case you have. The following provides some general types of documents you should be thinking about when you are preparing your case. Remember, we can't list every type of document, so think about your situation. Then think about what documents will help the judge understand your side of the case. In summary, any relevant backup evidence can only help your case. Sometimes you won't have any documents to present, but just because you say so doesn't make it so. Therefore, if you have anything to help you prove your statements, like documents or witnesses, bring them to court. Now, let's move on to our final scenario and look at expert evidence.
Work for the ABC Auto Repair Company.
In some cases, it is important to provide an expert witness. An expert witness can give the judge what we refer to as opinion evidence. The expert has some knowledge that is unique due to their educational background and training or related experience. This unique knowledge gives the witness the authority to give an opinion on a particular subject. In this scenario, the plaintiff has brought a mechanic in as an expert witness because of a dispute over a brake job that had been performed on the plaintiff's vehicle. The plaintiff wants the expert to testify that the brake job was poorly done. But before the mechanic can offer his opinion as evidence, it's up to the plaintiff to have the mechanic qualified as an expert in the field of automotive repair, and especially in this case, that the mechanic has special knowledge of brake repairs. The first step then is to establish the credentials of the witness.
What is your occupation?
I am a licensed mechanic and I work for the ABC Auto Repair Company.
And how many years have you worked as a licensed mechanic?
10 years now.
Do you have any papers or certification for brake repair?
Yes, I do. I took a 2-year automotive service technology course at a technical college.
Do you have a copy of your certification with you today?
Yes, I do. I brought 2 copies with me.
Could you pass a copy up to the clerk, Mr. Boylan, please? Madam Clerk, would you please enter that as the next numbered exhibit?
Can you estimate how many vehicles you've performed brake repair work on?
I'm not sure the exact number, probably between 200 and 300 separate brake repair jobs.
The plaintiff has now established the qualification by carefully going over the experience and training that the witness has. The plaintiff is now ready to ask the judge to have this particular witness qualified as an expert.
Your Honor, I ask that Mr. Boylan be qualified as an expert in brake repair, entitling him to give opinion evidence.
Thank you. Mr. Glenn?
When a judge qualifies an expert witness, they pay special attention to the type of expertise the witness has. For instance, the judge qualified Jim Boyland as an expert in automotive brake repair. The judge did not qualify him as an expert in automatic transmission repair or general automotive repair for that matter. This is important because if the expert witness attempted to give opinion evidence on the repair of automatic transmissions or cars in general, the judge could interrupt the witness's testimony to remind him that he is only qualified as an expert to give opinion evidence in brake repair work.
Mr. Boyland, have you done any repair work on a 1992 Ford Ranger?
Yes, I have. You brought the truck to me to check on the brakes.
And what did you do as part of your check on the brakes for the truck?
Well, the first thing I did was I took the vehicle for a test drive to see how the brakes reacted to a road test.
The plaintiff must clearly establish exactly what her witness did as part of his examination or work on the plaintiff's truck before he gives his opinion evidence. This is very important because the judge needs to be persuaded and convinced that the expert witness thoroughly inspected and checked the brake repair work and that the witness's opinion evidence is legitimate. In other words, the expert witness cannot come out and simply say the previous job was a bad one. To be convincing, the witness has to set out all of the steps that he took to examine the previous brake repair work. Once the witness has informed the court of all the checks and tests they have done, they're entitled to give an opinion of the quality of the previous repair work.
Did you come to an opinion as to the quality of the previous repair work done by the other repair company?
Yes, I did. In my opinion, the brake repair work done by the other brake repair company was done incorrectly.
And how did you come to that opinion?
I came to that opinion because of my examination on the brake drums.
The witness has now given his expert opinion on the previous repair work. Some of the important points that you should remember when bringing an expert witness to court are: you must establish the qualifications and reasons why your witness should be qualified as an expert, and why they are entitled to give opinion evidence in their area of expertise. You must have your witness explain their training, education, and experience. If your witness has been previously qualified as an expert in other court proceedings, you should make sure they mention it. Once qualified, the expert has to establish what they have done in your particular case to gain the information that they can render an opinion on. Once you have done all of these things, the expert witness can then give opinion evidence. As you can see, there is a lot to know and a lot to remember when appearing in court. The better organized and prepared you are, the better your chances are of being successful. Be aware that at the conclusion of your trial, the judge will usually award costs against one of the parties. These costs may be a nominal amount, or they may be quite substantial. Some of the factors that influence this award and the amount of costs are the reasonableness of the party's conduct in bringing or defending the claim. In other words, higher costs are usually awarded against a party who had no case or a very weak case. Prepare yourself, your documents, your questions, and your witnesses in advance, and your court appearance should go smoothly. Good luck. Alberta.